For a will to be binding, you want to make sure it includes you as a testator or testatrix, naming someone to act on your behalf when you pass away, your executor or executrix, someone you trust to act as a fiduciary, to make prudent financial decisions, to keep your interest and the terms of your will honored. And you should name an alternate would be a good idea. Not necessary, but often a good idea in case something happens to your first named executor. If they're either unable to serve because they're disabled or incapacitated, or they've passed away before you, then you have a backup. And then you'll also want to name your beneficiaries. And good idea too to name contingent beneficiaries in the event something happens to one or more of your beneficiaries. Then you have a plan, so it's not just escheating to the state. It's going to the people your estate is going to the people you want it to go to. And then you should make sure it's properly executed before witnesses who are competent, who are disinterested. So it can't be like your family member. And they should be adults who are competent to testify. And they would also sign what's called an attestation clause. And that avoids having to take their testimony after you pass away. They've already given their testimony in this affidavit that they sign before a notary. And you might also say in your will whether you want any probate that may be needed to be with your personal representative, executor, serving without a bond and without the intervention of the court. So do you want your executor to have what we call non-intervention powers, which can simplify the probate process? In choosing an executor of your will, I've had those cases where there are a number of children and it may seem natural to name the oldest child because that's what everyone expects. And what I tell the client is it's what you wish. It's not what your family members wish. It's what you wish, not what I wish. I'm not going to influence you. No one, not even your neighbors, should influence you. Your wishes need to be what is front and center, first and foremost in your document that is created for you. So name your executor to be someone you trust, to be a fiduciary, to make prudent financial decisions, to put the terms of your will at the forefront, to really honor those terms and to represent your best interests and those of the beneficiaries who you've named, including on down the line to contingent beneficiaries. So it should be someone who's financially astute, who is level-headed, and most importantly, someone you trust. If you die without a will, what happens is the laws of the state of Washington kick in to determine your estate and your beneficiaries for you. So where your estate goes would be determined by the state of Washington instead of by you. And what they look at are the laws of an intestate succession. The term intestate means you've died without a will. Kind of the natural quote-unquote objects of your bounty. They look to, do you have a spouse? Do you have children? Do you have grandchildren? If you don't have lineal descendants, they're going to look at, are your parents alive? If your parents have passed, they're going to look at your siblings. And if your siblings have passed, on down the line to nieces and nephews and so on. So it's important if you have certain intentions on where your estate goes that you put those intentions in writing in the form of a will. For a will to be contested in court, there are certain time restrictions. So you want to be careful and consult with counsel in terms of a timely will contest. And the bases, usually what we see are the testator lacked what's called testamentary capacity. They basically did not know what they were signing the day they signed it and the effect that that document would have. They didn't know the makeup of their estate. They didn't know the quote unquote objects of their bounty. They were somehow unduly influenced, maybe a caregiver, or maybe an adult child or family member. Maybe they've drastically changed their will from their last will, and it just isn't consistent. And so those are some of the bases you see when someone wants to contest or challenge a will. But the important factor is that they do so in a timely manner. If you have any questions about having a will or not having a will or creating your estate plan, contact us through our website, clearwaterpnw.com.